Wonderful. Good afternoon, everyone, and thank you for taking time after what I know has been a long and full day. Particularly if you had the day off yesterday, the next day can feel very, very full. But we're going to talk today about the paid leave program. I'm Andrea Barton-Rees. I am the CEO of the Connecticut Paid Leave Authority. And today this presentation is for primarily HR professionals or those that have an HR function in their workplace. We'll start with the basics of paid leave, so not to worry if you're unfamiliar. And for those of you that are very familiar with both paid leave and family and medical leave, this may seem like more of a refresher, but I appreciate your patience because we have people at varying levels of experience and exposure to the paid leave program. So I'm just going to start by sharing my screen, and Amber will confirm that people can see it.
We can see your screen.
Wonderful, thank you. And then let me just do a couple more things so I can get started. All right. So today, as I mentioned, we will be talking about how paid leave applies to your business and offering some tools for the HR professionals or HR, the person that manages the HR functions within your organizations. Just a little bit about me. I started in this role last March, so it's been about 18 months or so. I do have a background in insurance. I worked for Chubb Insurance for almost 10 years. And I was the CEO at HARC, which supports people with intellectual disabilities and their families. Today, we'll talk about the program. We will make a distinction between family and medical leave and Connecticut Paid Leave program. We'll also talk to you about implementing both paid leave and FMLA in your workplaces. We'll offer you some additional resources, and we'll have time for questions and answers. So starting out by talking a little bit about the Paid Leave Authority, our primary mission is to provide accessible paid leave benefits and helping employers and administrators and healthcare professionals in their roles in administering paid leave. We have 5 primary responsibilities. They include outreach and engagement, so we appreciate the opportunity to be with you today. We develop all of the policies and the procedures that are needed to run the paid leave program. We establish the trust fund contribution rate, which by statute can go no higher than 0.5 or 0.5%, and we receive those contributions into our trust fund. We audit and approve private plans for those employers that wish to offer an alternative to paid leave. There's an opportunity to do that pursuant to the statute. And finally, we administer claims for paid leave benefits, and that will start by accepting applications in December and paying benefits in January. Here's a review of some of the key dates. We did start to open employer registration almost a year ago in last November, and employers started deducting contributions from worker wages, that 0.5% I spoke of, the beginning of this year. Those employers that wish to offer a private plan submitted their application starting in February, and those that are in the public plan are now making those contributions on a quarterly schedule that you can see outlined here. Starting on December 1st of 2021, those that have made contributions to the plan, contributing workers, sole proprietors, and self-employed individuals can begin to submit their applications for paid leave benefits. And those that are approved will be able to start receiving benefits effective January 1 of next year. We often are asked who's covered by the plan. So here's just a summary. Those who are covered are all employers that have 1 or more employees working in the state, and that does include not-for-profit employers and those that are private sector employers with unionized workforces. Sole proprietors and self-employed individuals may opt in, but if they do so, they have to remain in the program for a minimum of 3 years. Those employers who are not covered, with some exceptions, are the federal government and the state of Connecticut, with the exception of certain covered public employees. Those that work for municipalities or local or regional boards of education are also generally excluded from participation unless they too have what is defined as covered public employees. Non-public elementary and secondary schools are exempt from family and medical leave and the paid leave program and have been so for a number of years. There are other entities, however, that are also exempt as a result of other laws that may cover their industries, and that does include railroad workers and employees that work for sovereign nations, which would include our tribal nations in the state, those that may be engaged in interstate commerce who may work here but don't pay income taxes here, and the spouses of active military members who are still paying taxes in their home state and not here where they may be deployed. A bit more about what a covered public employee is. They are either a non-unionized employee of the state of Connecticut or a unionized employee that has decided to collectively bargain to be a part of the program. Employees that work for municipalities or local or regional boards of education are participants in the program if the unionized employees in those workforces vote through collective bargaining to be included in the paid leave program. If they do so, then everyone who works at the municipality and everyone who works at the local or regional board of education, whether they are in the union or not, are then part of the paid leave program. A municipality has a very broad definition, as we can see. It can include a town or a city, but it can also include a housing authority or a flood commission. When contributions are withheld by the employer or they're made by a sole proprietor or a self-employed individual, this is the cycle that those funds follow. Contributions are post-tax and they are based on the employee's FICA wages. Contributions, however, they are capped at the Social Security contribution limit, which as of this year is $142,800. So the employee 0.5% wages are collected by the employer and then remitted to the paid leave authority. We do validate that collection with information we have available to us from the Department of Labor and the Department of Revenue Services. Those contributions are deposited into the paid leave trust fund, which is managed by the Office of the Treasurer. And it is from that trust that benefits are paid. So now let's talk about what FMLA is and what Connecticut paid leave is. They have a relationship, but they are not the same thing. FMLA stands for the Family and Medical Leave Act. There is both a federal and state corollary of this act. And while both of these acts provide eligible employees the opportunity to take what we call job protected time away from work, meaning that they have the right to take that time for an eligible reason, and they have the right to get their job back when they return from that leave. Both of those leaves, as we sit here today, are unpaid, but sometimes employers can allow the employee to use, or they may require them to use some of their accrued paid time off to cover some of the time that they're away. Some employers actually do provide paid leave to their employees, and some either require or permit them to use either some or all of their accruals to cover the time that they're out. But when the family and medical leave law changes for Connecticut next year, some of these rules will change. Here's a comparison of what the rules look like now. If today an employee came and wanted to take family and medical leave, they would be eligible if in fact they worked for an employer that had 75 or more employees. And that employee would have to have worked for the employer for at least 12 months and 1,000 hours. And then they would enjoy that job protection I spoke of after 12 months. They would qualify for 16 weeks of leave in a 24-month period and up to 26 weeks of leave if they were taking that time for military caregiver leave. And an employer could require the employee to use all of their accrued time to cover the time that they're away on FMLA. When the law changes next year, this will change significantly. It will apply to all employers with one or more employees, with the exceptions that I noted earlier. There will no longer be an hours worked requirement, and job protection will attach after 3 months of employment rather than 12. Rather than having a 16-week period of leave in a 24-month period, there will be 12 weeks of leave in a 12-month period. The 26 weeks of leave for military caregiver leave remains, but there also may be an additional 2 weeks of leave if a woman is experiencing incapacitation during a pregnancy. And another significant change that should be noted is that an employer can still require employees to use their accrued time off, but they have to allow them to keep up to 2 weeks of their accrued PTO. So they cannot force an employee to exhaust their time. We often get questions about if an employee has sick and vacation and other kinds of leave in different buckets, what can I really compel an employee to exhaust. So the guidance that we give employers is this, that this rule actually came about because of testimony that was given while the law was under consideration. And the testimony came from employees that said when they took time off for FMLA, they would often have a special occasion, maybe a trip of a lifetime or a chance to go to a graduation that was out of state. But something happened earlier in that year within their 12-month period or their 24-month period, and and they used all of their time away and time off, so they couldn't then have anything available to participate in that important life event. So when you're considering which pool of time, if this is applicable to you, that needs to be exhausted, keep in mind that that pool of time that needs to be exhausted could more likely be sick rather than vacation, although you are it's up to each employer as to what they want to do. Just want to provide you with some context as to why that rule exists. And let's contrast that a bit to the Connecticut paid leave, which we sometimes refer to as CTPL. It does refer to the statute, the program, and the agency itself. It is a source of income replacement. It does not provide job protection. And we also refer to it as PFML, or the paid family and medical leave. Some of the reasons for income replacement and leave, they're actually the same. So if a person wants to take family medical leave without pay, or they also want to take family medical leave and seek income replacement, these are the reasons that would apply in both circumstances. You can take it to receive treatment or to recover from your own serious health condition, and that can include pregnancy or serving as an organ or bone marrow donor. You can take it for caregiver leave for a family member that has a serious health condition, or to bond with a child that is new to your family through birth, adoption, or foster care. Leave is available to care for a family member who's been injured on active duty, or what we call qualifying exigency leave, the ability to take time to deal with issues that are associated with a parent or a spouse or a child's deployment overseas. And finally, what is very specific to Connecticut's law is that up to 12 days of leave are available to address issues that are directly associated with experiencing family violence. Our state has a Family Violence Leave Act, which allows a person to take up to 12 days of leave to address issues that are associated with family violence, which can include going to court, seeking shelter, finding a new apartment, new housing. Up to 12 days of leave is available for those purposes, but now those can also be compensated days with income replacement under the Paid Leave Act. What about what caregiver leave really means? When the law changes next year, the definition of caregiver will expand significantly, and it will include all of the categories you see listed here: a parent, a spouse, and a son or daughter of any age. And this is significant because right now you can only take leave to care for a child if they're under 18 or if they're over 18 with a disability. And so this change means something more than it did in the law as it currently exists. You can also take care of siblings or grandparents or grandchildren, or as we would refer to this, a relationship by affinity. And that means, we'll just go to the next slide, it is really any person with whom the person has a significant personal bond. That's like family, but not necessarily connected by biology or legal relationship. So that could be a couple that has been living together for a significant period of time. They may or may not have raised children together. They may own property. They may be beneficiaries of one another's life insurance policies, and the like, but they are not legally married in the state. They, with the appropriate documentation, could demonstrate that they are in fact related by affinity, and then apply for, and if qualified, receive paid leave benefits to care for the other person. A bit of a summary of the eligibility requirements in order to access the different types of job protected leave and paid leave benefits. The Federal Family and Medical Leave Act has not changed. And if you are an employer of 50 or more employees, you had to have been employed by the employer for 12 months and worked 1,250 hours. Starting next year, in Connecticut, as I mentioned earlier, you only have to work for the employer for 3 months, and there's no hours worked requirement. In order to qualify for paid leave benefits, however, not only do you have to have worked in the state, you have to have earned at least $2,325 in the highest earning quarter of the first 4 of the 5 past completed quarters, and you can do that with 1 or more employers. You have to either have been working here in Connecticut, or if you're applying for your benefits, you were working 12 weeks immediately prior to the time you apply. If you're a sole proprietor or self-employed, there is a residency requirement for self-employed individuals and for those that have opted into the program. A summary of the entitlements, which I reviewed earlier, so I won't spend a lot of time here. I did speak about the 12 weeks in a 12-month period and up to 26 weeks, and the additional 2 weeks that may be available for incapacitation during pregnancy, and the 12 days for family violence. Those reasons are reasons that you can take leave for job protection, as well as the reasons to access paid leave benefits. So now let's talk about what needs to happen as an employer to implement the Paid Leave Act. And we'll talk about the different roles. So for example, to start with, making contributions to the trust fund. The worker is responsible for contributing 0.5% of their FICA wages up to the Social Security limit. The employer needs to come onto our site, if you haven't done so already, which is ctpaidleave.org, create an account, deduct those wages, and remit them to the authority. Our responsibility is to receive and reconcile those contributions, process any payments, whether they're overpayments or underpayments, and we also statutorily have the authority to impose penalties for non-compliance, which we have not done so yet, but may do so at the beginning of next year. The Connecticut Department of Labor is the department that determines whether or not, if you've not yet withheld, you can have extra time to do so, so that we can make sure that your employees have contributed to the fund. For paid leave claims, let's walk through these rules as well. The worker will be responsible for submitting an application in a timely fashion. They too need to create an account in order to submit important documents securely, which may contain personal information or HIPAA protected information. They do have to provide supporting documentation for their leave request, and they have to update their account with any information that would let us know about their absences, if they've been approved, or if they have other sources of income that we should know about that might affect their benefit amount. It is the worker's responsibility to notify the employer about their claim and their absences from work. You will, as an employer, receive documentation and information from AFLAC, but your worker has an obligation as well. The employer's responsibilities include completing and verifying that person's employment and validating absences as needed. You'll need to let them know about any of your paid time off or FMLA absence policies, including whether or not there are any short-term disability policies that might affect their amount of benefit from the paid leave program. And and we always say this, to refrain from discriminating and retaliating against a worker. And this isn't because we think employers deliberately engage in this behavior. It is because employers, especially those that it's 75 or fewer employees, have had no experience with the Family and Medical Leave Act, or obviously none of us have had any experience with paid leave. So inadvertent discrimination and retaliation can happen. Our responsibility at the Paid Leave Authority is to determine eligibility and to monitor claims and to assess requests for reconsideration. We're also responsible for investigating any potential fraud claims, and we do have the right under the statute to impose penalties as appropriate. It is the purview of the Department of Labor to hear any appeals for the denials of claims and for the imposition of penalties. Let's walk through the process a little bit more carefully. So the worker submits a claim, and they do that by calling AFLAC, but they can also, they can call, they can go to our website, they can fax it, or they can mail it. They need to submit their application, and supporting documentation will include, but is not limited to, their reason for leave, the type of leave, whether or not they have any other sources of income that would affect their benefit amount. And AFLAC is the one that determines their eligibility with oversight from us at the Paid Leave Authority. And they also determine whether or not the claim is approved. If there's documentation that's missing, they'll let the worker know that. If the claim is denied, we'll also notify the worker. We also notify the employer, and we also let the worker know that they have a right to ask for reconsideration of the denial decision. If the claim is approved, Aflac uses DOL and other sources of data to make sure we have all of the data we need with respect to earnings as we calculate the base weekly earnings, because that is the foundation upon which the calculation for weekly benefits is made. After those benefits are determined, payments are issued either in a debit card or directly to bank accounts. There are no checks that will be issued for the paid leave benefit. They are issued every Tuesday, and they will be issued 2 weeks in arrears. And the benefits, for example, that would be a person for whom a person would be eligible for 1/2/22, they will get those benefits on 1/18, as an example. Now, the worker also has a responsibility for letting Aflac and the agency letting us know at the Paid Leave Authority any changes that happen to their work environment that may affect their benefit. And that includes the start or end of their leave, if they have any income, if they change jobs. If they're on intermittent leave, then we are requiring them to check in with the Paid Leave Authority more frequently than they would if they were on block leave, because intermittent leave tends to change more frequently than block leaves do. So block leaves are week, 2 weeks, 3 weeks at a time. Intermittent leave, a day here, 3 hours on one day, 5 hours on another day. Those are usually a little bit more challenging to manage. So we ask people to check in more frequently to do that and to make sure that we still have the right schedule for their leave. So once a person's done all of that, exactly how much do they get? So if a person's base weekly earnings are less than or equal to the minimum wage multiplied times 40, the maximum they can get is 95% of their weekly earnings. If they earn a bit more than that, they still get 95% of 40 times the earnings, plus 60% of the difference between their earnings and the minimum wage multiplied by 40. It is as convoluted as it seems, and I have an example after this, but it's no matter what happens, everyone is capped at 60 times the minimum wage, which right now is $13, that's $780 a week. Here is, excuse me, here are a few examples. So worker A earns minimum wage, and this, based on the statute, is a pretty simple calculation. They get 95% of their base weekly earnings, which are $520, so they get $494 in benefits. Worker B earns a bit more, $13.50 an hour. Their base weekly earnings are $540. So they're getting the 95% of the $540 plus 60% of the difference between $540 and $520, which is the minimum wage. And that number is $12. So they get $494 plus the 12, so they get $506 in benefits. Lots and lots of questions about how paid leave benefits works with any other type of employer paid time off. So these are 3 different scenarios that we hear a lot that I would like to share with you today. An employer, under the new law, you can still require or you can permit a worker to use their sick or their paid time off while they're out on approved leave, provided that, as I mentioned earlier, they get to keep their 2 weeks of leave. And we know that. We just talked about that. But if they don't receive any employer-provided PTO, the Paid Leave Authority will pay the full amount of their wage replacement based on the formulas I showed for the full amount of the leave. If they receive employer-provided paid time off that's equal to the full amount of time that they're out on leave, then they don't get any of that leave. Now, we often hear in webinars, well, if the employer offers full sick leave, for example, and I have a person collecting 0.5%, then why are they contributing the 0.5%? And the reason is this: it is an insurance policy. It does not sort of work like your personal health care savings account. So all of the money is pooled. And people often switch jobs. So even though they may be working for an employer that may offer sick leave, if they go to another employer that doesn't, then they don't have that anymore. And they can then rely on the paid leave program. But if they haven't been contributing to that program, then their access to the program will be compromised or limited. A bit more about the intersection between PTO and Connecticut paid leave benefits. Now, if the worker is getting employer-provided PTO that is equal to their regular pay, then they can get for any portion of the time that they're out. So let's say they're out for 5 weeks and the employer can provide them with, and they have 4 weeks of PTO, let's just say the 4 weeks of paid time off, they get to keep 2. So the employer is going to say to them, you need to use your 2 weeks of PTO. You're going to keep the remaining 2 weeks, but you can go to the paid leave authority to get your other 3 weeks covered. If their paid time off is less than, then we essentially pay the difference between what they would get from their employer and what we would pay, but it can't be more than 100% of the worker's regular pay. Some things that workers should know as they're trying to figure out how to navigate this process. And if they're trying to determine what comes from their employer, what comes from paid leave, a few things they should be asking. Whether or not the employer will require them or permit them to use their PTO while they're out on leave. Obviously, requiring and permitting means a different calculus for their decision making. If there are any rules about how that time can be used, if in fact there is a short-term disability policy and what the terms and conditions of those policies are. Does it say that the employee has to use all of their employer PTO first, or does it mean that they have to use all state benefits first? Some of these things are questions that, as the HR professional or as the person responsible for HR in your department or your agency or your place of employment, you're going to want to ask these questions too, so that you can have a full picture of what it is that needs to happen when a worker asks for income replacement when they're out on FMLA. Now, let's talk a bit about FMLA. As I mentioned, it's the Family Medical Leave Act, and it is changing in the state of Connecticut. So what happens when a person comes in and asks for family and medical leave claims? Now, remember, family and medical leave, if a person has worked the requisite amount of time, which is 3 months for job protection starting next year, with no hours worked, family and medical leave is an entitlement and cannot be denied unless the person actually doesn't meet those 2 criteria and doesn't have a reason for leave that's covered under the statute. The worker is responsible for letting the employer know that they need to take time away. They must offer 30 days at least for non-emergency circumstances and as soon as practicable for circumstances that arose that they had no control over. They had appendicitis, whatever that situation might be. They are responsible for giving the employer the supporting documentation, and they have to comply with your attendance and call-in policies. The employer really has to let the person know about those policies, including any rules that may apply about PTO usage. They are responsible for monitoring the leave usage and processing requests, managing their return to work, and again, refraining from discrimination and retaliation. How does that happen? Here's how it happens. And more employers than not get themselves in trouble this way. A person leaves for FMLA, a person comes in to replace them, their replacement is fantastic, not really excited about the person who's out. And then what happens is that the person who was out returns and they, for some reason, are not returned to their job, or if their job no longer exists, a substantially equivalent job, meaning same rate of pay, same shift, same everything. Even if the title might be different or someplace else that's to be discussed, that is a form of discrimination and retaliation. And it happens often, and that's why we try to forewarn employers to not do that because it can be troublesome. With respect to FMLA claims, the Pay Leave Authority doesn't have any responsibility about this. We're just letting you know because there's such a close relationship between family medical leave once a person takes that leave and they're seeking income replacement at the Paid Leave Authority. It is the Department of Labor that is responsible for promulgating all of the regulations regarding FMLA and providing employers and employees guidance around this. And they are the ones to whom an employee may complain about a denial of FMLA benefits or any allegations of discrimination and retaliation. A bit more about how the job protected leave process works. So it is the worker's responsibility, as I mentioned earlier, to notify the employer that they need to take time off of work. They don't have to use the term, I'm coming in to take FMLA. If they're saying, I need to go out to have surgery, I'm going out to have a baby, I'm going out because My mother is sick and I need to be with her for the next 3 weeks or so because she has a serious health condition. All of those things are FMLA, even if the person ever walks in and says, I need FMLA. Again, as I mentioned earlier, they need to provide you with 30 days advance notice if the leave is foreseeable, but as soon as practicable if it's not. It is the employer that determines whether or not the worker is eligible for FMLA. So this is a two-step process. They come in, they say, I need to take time off because, again, my mother has been diagnosed with a serious illness and I need to take 3 weeks off to attend to her. That is an FMLA trigger. Say, okay, that sounds like it may be an FMLA protected type of leave, but here's the paperwork. Go get this filled out by your mother's healthcare provider and bring it back. And that's in a later stage. But so what you're doing when they come in, they say to you, I'm going to do this. You have 5 days to let them know that they're eligible, meaning they're taking time off for a reason and it's covered by FMLA. But this is not the same thing as the leave approval. And so here would be the difference. Let's say they came in and they said to you, I need to take 3 weeks off because I need to, care for someone who's not covered under the statute, or I'm taking it for a different reason. I'm going to be with my sister because she's bonding with her new infant. That's not a reason under FMLA. And you would deny that person the ability to take leave. Next slide. Let me go to the next slide. So then the worker is responsible for coming back to you with all of the required documentation, medical certifications, adoption documents, whatever it happens to be. They've got 15 days to do this. If they are having a tough time, you can extend it another 15 days. There's some case law that suggests you can even extend it an additional 15 days and they still don't have it to you in 45. You can deny that leave if they haven't gotten the paperwork back to you within that period of time that you've provided to them. Now, once they've gotten everything back to you, then you are making a decision as to whether or not the person can have the approved FMLA leave. You have 5 days to do that once they get you all the documentation back. And then you have to tell them what the terms and conditions of that leave are, including whether or not they have to use their PTO, how they have to report in, and whether or not they will need to provide a fitness for duty before they come back to work, keeping in mind that with few exceptions, they don't have to be 100% fit for duty to return. Now, the worker reports to the employer when the worker actually takes their leave, and it's the employer's responsibility to track it. If your policy is when you're out on FMLA, you need to call within 3 hours of your window, or you need to let us know, and they don't do that, then they can be subject to discipline. And the employer has to keep track of the time that they use to make sure they don't exceed their 12 weeks in a 12-month period. Now, the employer has to bring the worker back to the job they had before they went out on leave. Again, I mentioned earlier, same job, same conditions, same terms. They don't have to be 100% or totally recovered. And you may also have some other laws that you have to take into consideration, which I'll go over in a moment, to determine whether or not they can return, or you have an obligation to provide what's known as a reasonable accommodation to allow them to return to work in some form. So if this sounds complicated, it's because it is. There are lots of complicating factors for managing family and medical leave, and we know that's because there are a plethora of attendance policies and call-in policies, and they may not return their paperwork on time, and if it comes back, it's not complete. And then there are people who take intermittent leave, and then there are the folks that have fluctuating work weeks, different schedules from week to week. There are other laws that also may be impacted: federal FMLA, Connecticut FMLA, and workers who don't want you to designate their leave as FMLA because they want to keep their leave for what they consider another time that leave might be something that they really need. So let's take an example. Let's say that a worker has, they're expecting to have a baby in month 5 of their 12-month period in which they might be eligible for leave. But in month 2, she breaks her arm and she requires physical therapy, and then she develops some sort of infection. So now she's got a serious health condition, if that's how her doctor defines it. And she may say to you, oh, I don't want that to be FMLA because I know I'm going to go out and have my baby at the end of the year. And so I want to save my FMLA for that. The answer is no. Under every circumstance, it's your right as an employer and it's your responsibility to designate any time off as FMLA as leave, because the job protection is really what's critical here. So you'll have employees that will do this, and we understand why, but you can't let them do that. Speaking more specifically about all of the laws that protect jobs of people out on leave, you see them all on the left side of the screen. They include the Americans with Disabilities Act, the Pregnancy Disability Act, and the Connecticut Fair Employment Practices Act. We could teach a whole seminar on this on its own, but there are now 2 laws that provide income replacement and workers' compensation, which will remain the same, and Connecticut paid leave. Keeping in mind that a person who is receiving workers' compensation or unemployment benefits is ineligible to receive paid leave benefits at the same time. I've talked about a lot, I know I have, but there are lots of places where you can get additional resources that primarily on our website, ctpaidleave.org. If you go to the employer page, you can find all of these informational resources available to you, including an updated toolkit for 2021. There is also on the site now, if you go to the section called the process on the home screen, there is a section for small businesses, and you can direct your employees to a section for their own, to learn more about their own benefits. I'm actually going to stop sharing and just go into the paid leave site and show you that for just a moment, if you will indulge me, because I think they're worth seeing. And let's see. Right.
Andrea, I actually have that up right now if you'd like me to pull it up.
Yeah, why don't you go ahead and do that? That'd be great. Thank you, Amber. And maybe that's the option, Amber, is to ask you to share it afterward.
Okay. Bear with me for just a second. Okay.
All right. So thank you, Amber. This is the paid leave site. So if Amber, if you'd go to the process, this is the home page. We've added 2 new functions to the site. The first is to prepare to submit a claim. Oh, let's go back up to the top. Yeah, prepare to submit a claim. This is a new addition to the site. And if we can click on that for a moment, then we'll come back. Great. And if you scroll down for me, this now provides a summary of everything that a person needs to do in order to submit their claim step by step. Again, not effective until December of 2021 for submitting claims, and then claims will be paid in January of 2022. And if you can go down just a bit more for me so we can get to the benefit calculator. Okay. So there's a checklist that a person can download, but what we hear most often is a person wanting to know exactly, how much they will get. This is an estimator because there are all kinds of factors that may impact how much a person can get, but you can send your employees to this page where they can put in their own, maybe Amber, if you can click on that, select an option for me, and you can see the frequency of a person gets paid, and then maybe you can put in a dollar amount of $500, and then we can estimate what a person would get. They would get $475 a week, right? Which is 95% of their weekly wage. Okay. All right. If we could go back, let's go to the small business. Thank you. All right. And then we'll scroll down a bit. So these are actual small businesses in the state of Connecticut. The toolkit can be downloaded. There are other places where you can visit. So I'm actually going to go to the toolkit really quickly. Nope, toolkit. Nope, toolkit. There we go. All right, toolkit, there we go. All right, so you can see it's a 19-page document. We're just going to scroll down to the table of contents, and you can see that it includes everything that I spoke of today, how paid leave differs from FMLA, who has to participate, what your role is as an employer. No matter the size of your business, we think that this toolkit is going to be very, very helpful to you. And then Amber, can we just go back and go into the HR toolkit for a moment? So this is brand new. We just created this and added it to the site maybe a week or two ago. And this is specifically for HR professionals or those that have an HR function in their organizations. It outlines everything we spoke about, the eligibility requirements, but maybe we could just go down a bit because it's designed a bit differently, where you can actually make copies of each of these pages if you needed to and post them in your workplace if you're back in your workplaces. The qualifying reasons for leave, you can take screenshots and put them on your website or your intranet if people still have such a thing. So it's designed really for you to be able to sort of cut and paste and use. And the other documents that I was showing you earlier, okay, and thank you, Amber, because this is perfect. So the process for when a worker tells you they're applying for leave is in a workflow right on this page. This is page 5 of the toolkit. We're finding that employers are downloading the employer toolkit and the HR toolkit together and using those as reference tools. And that's why they're there. So please, we encourage you to use them all. Okay. And then, so again, there's more information about how to apply for paid leave. There's examples of the forms people will have to fill out. There's charts that define, as I tried to do here, what the roles and responsibilities are. So we tried to put in a lot of information that you can refer to again and again. Okay, I think I'm good here, Amber. I think we're gonna stop sharing and go back and answer. I think I only see one question, but we'll go ahead and do that. Thank you very much for doing that. It was very helpful. Let me get back on screen and let's see. All right. So let's see, we have one question. If an employee's weekly income exceeds 780, can the employer use a company paid STD and pay them up to 95 without them having to claim it through? Well, that's an interesting question. And the answer is a conditional yes. You can do that. All we know is that as long as at the paid leave authority, we're not exceeding the payment of their weekly income, and the most that they can get is 780. If you'd like to kind of top them up using the short-term disability policy, you certainly can do that. And they don't necessarily have to, let me just see this. Let me just read this carefully. Can you? Yes, you can. But they still have to tell us that they have an STD policy, because we'll have to consider whether or not it will have to, whether or not it will have an impact on their benefit amount. Okay. Let's see. Does the website offer any policy templates that can be used? No, we don't offer policy templates. And that actually it's a great question. Thank you for that. But it's a deliberate decision. We're asking employers to work with their employment council to get policy templates for their handbook, because we've noticed that there are so many variations in industries that we couldn't really offer a policy template that would be applicable across the board. So we have not been doing that. Okay. Yeah. So I see those are only a couple of questions. Are there any others that anyone might have? Because we are going to wrap up early. I know it's late in the day. It's been a long day. If there aren't any other questions, I really want to thank you for your time today. As Amber mentioned, this webinar and the slide presentation will be available to you if you've registered and participating. And we send it out to all registrants, even if they couldn't make it today, because we'd like everyone to have the information. Please explore the website and reach out to us at our contact us if you have any questions. That's all I saw. Oh, we're all set with the questions. Oh, thank you. We appreciate it. Thank you very much. We appreciate your time. Have a wonderful evening, everyone.
Thank you, Andrea. Have a good night.
Thanks.